Hello, everybody. Do we have, my name's Deborah Sloan. We're gonna get started on this webinar in a minute or two. And this is a training on dependency law. It's aimed partially at service providers, but to help the service providers inform how to counsel clients navigating through all phases of the dependency case, answer questions you might have about child welfare. There may be advocates and parents as well. We have, you can add questions to the, there's a question and answer box, and there's a chat box, and you can put questions in there, and the panelists will try to address those. And I'm your host, Deborah Sloan, staff attorney at Legal Services for Prisoners with Children. And Legal Service for Prisoners with Children has been fighting for the rights of incarcerated persons and system impacted and formerly incarcerated persons for over 40 years. And we're working to improve their lives through policy changes, through legislation, through outreach, advocacy, and action. And I was a panel attorney at Alameda County in dependency, delinquency, and family law for over 15 years. So I have a real interest in this issue. And let's go ahead with Los Angeles Dependency Lawyers Incorporated, who is the primary, I don't know if it's the primary, represents parents in a dependency court in Los Angeles. And that is a huge population, and one of the more, I think they have the largest number of cases any place in the country. So Frank and his staff are here to present.
Thanks, Deborah, and welcome everyone. So as Deborah was saying, we're Los Angeles Dependency Lawyers attorneys, and we're part of a special committee that's focused on spreading awareness of dependency law and the work we do in communities throughout California. I'm joined by Liz Melendez. I'm just going to introduce you guys just for the sake of efficiency. Liz Melendez is a social worker investigator in the law office of Jolene Metzger. Before that, she worked in the 211 office for a while. And so she's very familiar with the resources that are available to help parents with various issues, and especially knowledgeable about helping parents with housing issues from her experience. Next, I'm just going in order of the boxes I'm looking at. So it's no particular order. It's Ben Falcioni. He is a staff attorney in the law office of Emily Berger. And he's also joined by Sarah Tavacoli, who is also a staff attorney in the law office of Rachel Ewing. They both have caseloads of about 150 clients, and they've been doing this about 2 years now. And finally, there's Cameron Hightower, who just joined us. She is also a social worker investigator in the law office of Emily Berger. And she's been, I'm not sure, but she's been with that office for a few years now, at least 5 or 6 minimum, from what I could tell. And I'm a supervisor in the law office of Martin Lee in the Los Angeles Dependency Lawyers. Collectively, we have probably 15, 20 years of experience, probably more than that, in dependency law. So as you can see, there's no template here. We know that a lot of the people here are service providers or dependency adjacent, and we wanted to encourage people to ask questions. So if you think you're interrupting, you're not. We're actually comfortable with that. We're all pretty familiar with what it's like to be in a courtroom and talking with clients and other people. So we're used to being interrupted, but we want to hear your questions. We want to know exactly what your issues are in Northern California. One of the benefits of us being a Los Angeles organization is that I don't think there's a conflict of interest. There's very little chance of that, at least, in terms of questions you might have related to dependency in Northern California. Now, with that said, we will generally, we prefer hypotheticals. Don't mention specific names or specific cases. Just talk about like, what if this, what if that? And we'll try to answer your question in accordance with our experience and the requirements of the law. Truth be told, I actually thought I was going to be able to see more people's faces, so I was going to ask for a raise of hands. I don't know if we can do that, but I wanted to know if anybody has dependency experience. So my first thing is a question to you guys. Do you guys know dependency? Because I want to cater to what you guys already know or don't know. So that we're not just generally talking. Is there a way to do that, Deborah?
I see, I opened up a list of the names, but I'm gonna have to ask Mark to help me get their pictures up. Let's see.
People can raise their hands. But...
Oh, they can? Okay.
Can't see anyone, but that's fine. I was just gonna start off, and again, please interrupt if you have a question about something that you've come across in dependency. With a general overview of what the dependency timeline looks like. And Mark, do you mind sharing your screen so everyone could see that slide or that PDF? Okay, so here's a flow chart of what dependency proceedings look like. So how dependency law works is someone calls DCFS or your local CPS agency, and the government through that agency is required to investigate a child welfare, child neglect, or child abuse referral. But it's just an investigation. That's all a referral is. From there, they make the decision of categorizing the case, their referral, as one of three things. Either they say that it was unfounded, meaning there is just no evidence to support the referral that was called in. I don't know, again, how much experience people have here, but that does happen. People call DCFS or your local CPS or SSA agency or social service agency in retaliation to get after other parents. And every once in a while, it's just an unfounded referral. A lot of them are unfounded, actually. Next, you have inconclusive referrals where there's some evidence, but they're just not sure. They don't want to say yes or no to it. And then finally, you have substantiated referrals. And those referrals are elevated to one of two things, either a voluntary family maintenance case where the children remain with the parents, but there's no case filed, or they file a petition. And that's that orange, tan, peach box that you're looking at on the flow chart, dependency petition filed under Welfare and Institutions Code section 300. Basically, they're alleging one of the subdivisions of WIC section 300 have been met according to the facts, and they want to file a petition with allegations in it regarding child abuse, child neglect, etc. And then once they file that petition, there's an initial hearing. Historically, we call that the detention hearing, but that's a bit of a misnomer. It can be confusing. We're starting to change the vernacular, and we're only calling it initial hearings now. And at that initial hearing, basically you meet your lawyer, the parents meet their lawyer for the first time, and attorneys are assigned, and the attorneys make an argument for whether or not the children should be released, should stay released, or whether or not the children should go to a family member, or they just submit and say there's no issues here. We agree with the department's recommendation. And just to speed along, what they also do is set a trial date. So what it basically is, this initial hearing, it's the dependency equivalent of an arraignment in criminal court. So at the arraignment in criminal court, they set a trial date, and they do the same thing in dependency, and that's called the jurisdiction hearing. Basically, that's to determine whether or not the court can find that the allegations in the petition regarding, domestic violence, physical abuse, sexual abuse, emotional abuse, etc., can be found true by a preponderance of the evidence. And what does preponderance mean? I'll give the analogy that I give to all my clients so they have context. It basically means anything over 50%. It's a coin flip and a grain of sand. Everyone thinks it's 51%. It doesn't necessarily mean 51%. It could be 50.0001%. And it's a far cry from the standards in criminal court where the standard of proof is beyond a reasonable doubt. So basically, it's easy for the department, for the government to find, to prove that the allegations are true because the standard of proof is so low. It's just a tiny bit over 50%. And you got jurisdiction over the child. And the reason for that, because I've wrestled with this for a while, is because society places an importance on protecting children, understandably. So it doesn't take much to get the ball rolling to take jurisdiction over a family so that services can be ordered thereafter. And that's where we go, that's what leads to the disposition hearing. At the disposition hearing, that's when the court orders whether or not the children can stay with one or both parents or more parents, and what services are ordered to basically close out the case, or in some cases, if a parent is not offending, meaning they're not part of the petition. They're a parent, but they didn't do anything wrong according to the government, that the case can close at this disposition hearing early with that parent having custody. And the standard of proof for whether or not a child can be removed from a parent at this dispositional hearing is the highest standard in dependency law. It's called clear and convincing evidence. And I will say a lot of the law is written that way, where there's a default where the children should stay home or go back home with an emphasis on reunification. But I see questions, by the way, and I will get to them momentarily, or one of us will get to them momentarily. I just want to finish my thought on disposition. The law is written in a way where there's an emphasis on reunification and family maintenance, but in terms of practice, what's written on paper is very different from how the law is practiced. A lot of bench officers, a lot of attorneys, because the children get attorneys as well, are in constant CYA mode. So it may be written this way where the default is that the child should be placed with a parent or both parents, unless that clear and convincing standard for detriment is met, or risk of detriment, but it doesn't really play out that way, unfortunately. I see a question here. I'm gonna go backwards. I know there are earlier questions, but there's one from Robert Kemp. Why would you call it a detention hearing in the first place? It's not a 602 WIC hearing like what you have in probation. I'm gonna go with Sarah. Sarah, do you want to answer that question?
I'm just looking up 602 right now. I don't actually know how to interact with probation.
Well, 60.
I don't know. Well, does anybody know? Ben or Liz?
Well, I do if one of you guys don't, a little.
I just thought it was, my understanding is it's called that because the opportunity for detention exists, and that defines the standard that we all can argue with.
I'm sorry, Deborah, did you say you knew why we call them detention hearings?
I believe isn't that the statutory name for when a child is detained removed from the home, at least temporarily, and in the 602, that's the juvenile delinquency, and they also have a detention process. But I think that's a statutory language, if I'm correct. Sounds like I am.
Is anybody else having audio issues trying to hear Deborah, or is it just me?
Oh, is it just you? Oh, I'm sorry. Can you hear me a little better now?
I can hear you.
You can?
Yeah, I can hear.
Okay, it looks like other people can. I think it might be you, Frank, sorry. Okay. We don't have any open questions right now unless somebody wants to ask one.
If you guys can hear me, Ben, do you want to take over for a minute and just talk about what happens after the disposition hearing, just really briefly?
Sure, Frank. So a number of things can happen at the disposition hearing, but this is typically, as Frank was indicating, we have this as dependency attorneys, we have our highest burden of proof here. So this is where we really get to push to get the children returned to parents under that clear and convincing standard. And what DCFS needs to prove is, by clear and convincing evidence, is that substantial danger would exist to the children if the children were returned to their parents. So as practicing attorneys in the courtroom every day, this is essentially our best chance at getting a child returned. If the child's not returned, well, if we're successful and the child gets returned, the next hearing is a hearing set under Welfare and Institution Code Section 364. And that is our hearing to determine whether or not the case is ready to close. Okay. In general practice, the children are often not returned. When the children are not returned, the next hearing is set under Welfare and Institution Code Section 366.21E, and that's our 6-month review hearing. When the court makes the dispositional orders and does not return the child, the court will order the parent to comply with the case plan. This case plan involves programs that are tailored to help the parent address the case issues, namely any issue arising out of the allegations in the petition. So if it's domestic violence incident between the parents combined with or fueled by some substance abuse, the case plan would likely involve domestic violence counseling, probably some individual counseling, and certainly some substance abuse program, and most likely weekly drug testing. The parents will then they'll be ordered to comply with that case plan, and DCFS is then ordered to provide referrals to those programs, which often involves a single sheet of paper with some names and contact information for some programs. And then the parents are left to go ahead and enroll in those programs on their own, to pay for them on their own, and to regularly participate. This case plan is essentially part of the family reunification process, which means that DCFS will monitor the parents' compliance with this case plan. That means the social workers will contact the parent's individual counselor. They will keep track record of their drug testing. They will contact their substance abuse program and speak with their counselors there. They will just contact the domestic violence program if they were ordered to one, to see what the parent's progress is actually like. Essentially, it's not sufficient that they simply attend. The social worker is going to see what they're learning from these things, if they're learning anything, and if so, how are they implementing them into their life. Substance abuse program would certainly be implemented and into their life by showing that they're actually staying clean and sober. For domestic violence program, to see if a parent was implementing that into their life, they would ask the parent about what they're learning, what the warning signs are. They would ask them about the effects that they're having, that domestic violence has on children and their own lives. Assuming the parent gets enrolled and is in compliance with their case plan, that tees us up as dependency counsel, as parents counsel, for that 2-1E hearing, that 6-month review hearing, to make our next argument that the parent is in compliance with their case plan. They have been regularly participating in their programs, and that they are learning from these programs, and we now get another opportunity to argue to have their children return to their care. I see a question.
I'd actually be willing to answer that question from.
Go ahead, Sarah.
The efforts that are made when a case plan is assigned, the client is put in a position where they are starting to go up a hill, basically. So until you get halfway through your case plan, and I'll explain how you get help with that if you're in a financial disadvantage, you're always on defense at every next hearing. If you start to really dig deep into your case plan and make like over halfway progress, which isn't necessarily always what it takes, but let's say you get 3/4 of the way through it, then you start to get on offense. And for example, with domestic violence, I have clients that'll take a 52-week course. That's a year. And they'll still be, the department will still doubt if they've learned anything. So that's you're on offense in the sense that you need to start demanding that the department explain what risk still exists if they're just going to claim that the parent hasn't learned anything, when they're not giving the parent a chance to apply what they've learned. In regards to getting into services, we request low cost, no cost referrals. So that's great that you know the exact language. That doesn't really mean much. The social worker gives them a list of referrals. I have noticed some clients that aren't enrolled in Medi-Cal, for example, and I will specifically request the department help enroll them in Medi-Cal. The department makes, and depending on the social worker, they make a decent effort to try, but once it gets in the weeds a little bit, I have to start really encouraging my clients to literally go in person to try to start to get some results and just, be a squeaky wheel. And sometimes they don't have the motivation, energy, or ability to do that. They don't have a car. They don't really know how to advocate for themselves in governmental agencies like that. They're trying to balance visiting their kids, which are often placed in a city 2 hours away. So they're balancing so much that they're maxed out on bandwidth before they even enter and enroll into anything. So it's actually very scary and we're racing the clock. What I do as an example to protect my clients in that situation, when they're given low cost, no cost referrals, a lot of them have a wait list because they're being given to everybody. So I have clients that they're like, well, I called this place and that place, they didn't let me in. And I tell them, get a letter telling me you were turned away or that you were put on a wait list or that you weren't allowed to be put on the wait list. Or if you were told you're not eligible, tell me why they said that and have them write a letter saying why they said that, 1 or 2 sentences, and you'll get a better result if you go there in person and get that letter. And then you start again presenting evidence of the negative. I'm like, well, this is why my client isn't in their case plan yet. And I'm not, you don't get more time, but you start to make the judge cognizant of the disadvantages your client is facing. And you're trying to show those disadvantages are reasonable, it's reasonable that that person isn't knee deep in their case plan yet. So it's being an attorney in the position of representing the parent. There's many ways to try to protect my client. I've had success with some of those efforts with clients that are literally, they're financially drained, like they don't have housing. And because they moved out to accommodate the department because they did what they could to make sure that kid is with family, which is the #1 priority. So I hope that answers the question. I'm going to stop monologuing.
So to chime in on that question as well, that revelation always elicits a really strong reaction to people that we present to. And I get why. Even when we present to some conservative groups, like, I don't know if you guys know what CASAs are, but they're I forget what it stands for, but basically they're special advocates for children, court-appointed special advocates for children. And they're generally geared towards, they're volunteers that are generally geared towards helping children only, in kind of historically at least, though there's been more changes recently in our culture, not being so parent friendly. But when we tell even those volunteers that the parents have to pay for their services, they always react strongly because it's almost like the government is ransoming their children. It's like, oh, you have to pay this amount to get your kids back, when most of our clients did not go to college. A lot of them actually didn't graduate from high school either. Many of them are immigrants and have gone through generational poverty and lack of education. So you expect these people to pay, even if it's $25 a session for a domestic violence course. Sometimes you got to go to 52 of them. The most atrocious service that is almost always ordered is individual counseling. And it's really hard to find free individual counseling. Some of the cheaper places I know are still $50 a session. You're talking about people who are working 2 full-time jobs, trying to go to these classes and trying to pay rent so that their kids can at least once the services are done, can come to a habitable home. It just doesn't make sense. Now, what efforts are we making? This is actually one of those, or it's the hill that our organization is willing to die on, that there should be no services ordered without a plan for how to pay for those services. Our executive director, Dennis Smeal, this is the thing he wants to be remembered for, where he's he's trying, but there hasn't been much headway, at least in LA County. It's a good question because every county is actually different. If you go to Santa Clara County or Orange County, from what I heard, the government actually is ordered by the judge to pay for those services. That is not the norm in LA County, unfortunately, and it is something that we need to work on. One of the things that our organization has done to address the requirement of doing these services that still cost money is we have social worker investigators, two of whom have joined us today in terms of Liz and Cameron, and parent partners who are parents who've gone through the system, been able to reunify successfully, so therefore know a lot of the resources in LA County that work for our organization now. So it's very different. It's in every county in terms of having to pay for these services. So if you're in Northern California, especially someplace like Santa Clara, it's more likely that this norm doesn't apply out there.
In Alameda County, everything is paid for, but the process is to provide referrals that lead to nowhere, and you get sent to a central for psychological services and parenting classes and that sort of thing. You go through the access from Medi-Cal and there's never anybody available. It's the most frustrating experience that I noticed when I was dependency.
Especially in the pandemic, Medi-Cal
Yes.
and the pandemic. Because Can I say one more thing about what just to add that list of what Frank mentioned about the types of people that were the reasons that some of these individuals are lacking financial resources. One of them also could be we're dealing with people that already lost one of their kids because they didn't have financial resources to help get themselves the last kid back. So that may be something that a lot of incarcerated parents are actually familiar with. That I happen to have set many that they've lost the child before because they were incarcerated or they were out and they couldn't afford anything because an individual on probation in California has to follow 3,300 rules. That's a side note. But yeah, I just wanted to add that.
And there's a bill that's being that's up before the legislature. It's going to be part of our quest for democracy on Monday, and I can't remember which bill it is, SB or AB, but it's to provide incarcerated parents who are still they're waiting to be pre-conviction. They have to get reunification services while they're incarcerated. I don't remember which one that is. And then also there's the 1085, which I know you guys are co-sponsoring or participatory in some way, that adds homelessness and other financial disadvantage to the list of reasons that children can't solely be removed from their parents, if I said that correctly. And then we got 2158, 2159, and we've got another question here about.
Oh, well, hold on, Deborah.
Sorry,
Before we move on, I just
Okay.
wanted to answer the follow-up question from Ms. Lee, whether
you.
there are any lawsuits filed regarding this issue. So at the moment, our organization is focused more on the attract more flies with honey method. We're trying to work with the Board of Supervisors, and our executive director, Dennis, has written several letters going back and forth where they're effectively in agreement with him so far in principle, but they haven't really done anything in terms of effectuating law that requires that and we actually reference law that indicates that these services should be paid for. There are authorities that actually confirm that, but LA County is just stretched really thin maybe. So we'll see what happens, but we're actually still kind of in the initial phases. So this was the hill that Dennis Meal wanted to die on. But the moment he became executive director, there was also something called COVID-19 that hit at the same time. And that has delayed a lot of the progress that we've tried to make on this issue. I wanted to give Liz and Cameron an opportunity to talk about this issue as well. The question was about potential services that were available for indigent clients. Do you guys have any insight into this? What opportunities are available or resources?
Thank you. I have so much that we could talk about just in this specific subject alone. And both Cameron and I, before joining LADL, Los Angeles Dependency Lawyers, came from working directly at Edelman Children's Court in other capacities. So we brought that knowledge of dependency and the challenges that many of our clients face. Not the incarcerated parents face a different set of challenges, and we can talk about those as well. But for the average parent that enters dependency, if they're already a family that is disadvantaged, a family that is already socioeconomically challenged, this is going to be a very tough environment. They're going to be in a boxing match where they're going to have to go 12 rounds. It's just going to be that way. So when you're hearing our attorneys share that it's going to be a battle, it is. It comes down to a battle with our parents. And the battle is for them to have a right to get their children back, even though they're not being afforded the appropriate support and services to allow for that to happen. And to just give you a little bit more perspective, at least as it relates to our families in the LA County, who we serve, who we mostly work with, most of our families that enter dependency were already at or below poverty level. That means that we're already challenged with even just providing some basic needs at different intervals of their life. So when they enter the dependency system, the issues that they already had just become even more magnified. They don't have the financial means that perhaps others might have to be able to access resources. So they don't have private health insurance. If they're having to rely, as Sarah said, on Medi-Cal and social service support systems, while they might be able to access it at some point, that some point may not align with the window of time that they have to be able to reunify with their children. Now, I'm going to just stop for a moment. I just want you to think about that and what that means for your client. So this is not a parent that doesn't care about their child or their children. These are not parents that don't love their children. These are not even parents that acknowledge that something may have happened that may have put them at risk. These are parents that legitimately are open and willing to get the help that they need because they want to get their children back. But yet they're at risk of losing their child or their children. And in some cases, permanently, forever, because adoption is forever. And that is what we have to face every day with our clients. Not to say that every case goes there. We do all of our best efforts to prevent that from happening. And this is why we can even sidebar and speak about how important relative placement is. But if we're talking about just the basic resources, they're not readily available. One of the easiest things that we have been able to successfully help our clients get into is a parenting class. However, it oftentimes may not be so easy if our client happens to be monolingual, any other language other than English. And I don't know if that's true for some of you that are here with us today, and if you're identifying with some of these challenges with your clients, but this is a very real challenge for our clients. So sometimes even the most basic thing that we could try to go out there and get for a client to just get the foot in the door isn't quite that easy. And I'm certain that Cameron and our attorneys can chime in about some of the experiences, in terms of their cases of even that simple challenge. We can talk about also the challenge of transportation for some of our clients that don't have a vehicle of their own or don't have the means at the cost of gas at this time to be able to put enough gas to get from LA to San Bernardino to visit one of their children and then go over to another part of LA County to visit another child, and so on and so forth. So those are some of the barriers and challenges that our clients face.
Cameron, is there any, I don't know if you're frozen or it's just me. Is there anything you wanted to add? Hello, Cameron.
No, what she said.
Uh-oh.
That's not just me, right? You guys,
No,
Right.
Cameron,
Yeah, it sounds like it's,
your
yeah,
audio's terrible, I'm afraid.
So yes, in fact, it is true that this is a systematic issue.
It
And-
is a I'm sorry, can you hear me okay?
Who's talking? Cameron?
Hello?
Is that Cameron? I hear you, Cameron. Maybe
So,
you better
Cam-
log back in. 'Cause
yeah,
you have a
Cameron, so
really
you're-
rotten.
you're like super laggy, but you are, we are kind of short on time. We got to rush through some
Okay.
questions that we haven't even addressed yet. And what Liz was saying could actually segue into 5 other topics that are pretty relevant to today's presentation. But since there are questions that are pending, does anyone want to answer? I know you did privately, Sarah, but maybe you can answer Lisa or Liza's question, Ms. Davis's question about how to handle situations with non-offending parents.
Yeah, so if the individual is non-offending, then they likely have the child placed with them, in which case my advice for them is, if it's DV, it's don't let the person visit who's the perpetrator. If there's a restraining order in place, have them follow it. If there isn't one, get one, or show how make my client look like she's dying to get a restraining order.
Right.
just like
Keep them
exhibit.
not offending.
Yeah,
If they're
keep them not-
keep them-
Especially, yeah, there's a lot of clients that when they do get restraining orders, and unfortunately, the toxic nature of their relationship when that case first starts leads them to violate it at certain times, sometimes without even knowing it. I have a client that went to the house to go get his things. He was to stay out of the house. He violated the restraining order.
Now, we are presenting with legal services for prisoners with children, and a lot of incarcerated clients are not offending in the petition, but they don't have their kids with them. Do you guys have any insight as to how we could handle those situations?
Well,
Sure.
go ahead, Ben.
No, it's actually quite a common non-offending parent situation where the one parent is incarcerated prior to the events that gave rise to the petition, and so a parent simply isn't named in it. Yeah, a couple of things often happen. One is the department will go ahead and look into why that parent is incarcerated and then amend the petition to make them offending. They love doing this. When a parent is non-offending, we have incredible arguments at disposition for placement. And if DCFS has it out for the family, which in my experience, they often do, they don't want this argument to be made or to be successful if it is made. And so they'll often do what they can to make the parent non-offending, whether that's adding them as making an inappropriate plan, which seems out of control, that the notion that they're incarcerated is an inappropriate plan to leave their children, or again, drumming up the reason for their incarceration and having it be an allegation against them. If the petition is not amended and the parent remains non-offending at disposition, our best arguments for placement is essentially placement with that parent, with them making an appropriate plan of placement with a fit and willing relative. So if I have a mother who's incarcerated, but maternal grandmother would like placement, then at least legally, the court would release that child to the parent with that parent making an appropriate plan. That's essentially basically, and Frank, maybe, or someone correct me if I'm wrong, but that's essentially the best we can do because a child's not actually going to be physically placed in the parent's place of incarceration. But it still is somewhat of a legal win in the sense that on paper, that child is released to this non-offending parent, and they can make the decisions such as educational and medical decisions from their place of incarceration through their appropriate plan, typically a relative, and that's sort of the best we can do. Well, and of course, there's non-offending parents that aren't incarcerated, but I won't get into that at this point.
Can I add something?
Sure.
We could have non-offending parents in one case for one child, whereas in a prior case on another child, they were offending. And for whatever reason, let's say they were incarcerated before they could complete a case plan. they didn't complete a case plan for that child, and they're arguing to bypass on this child because they didn't complete stuff for the last child. So that can be complex. So as an attorney, what I do is I immediately go into preventative mode. That's what I think Ben was alluding to, where you're just trying to place with that individual's family, show that person's family's involved, get in touch with that person's public defender if their case is live, find out what's going on with that, understand what the client in jail has opportunities to do to shorten their time, which could mean going to a prison 5 hours away where they won't be able to visit with their child in person, given that that's not really happening during COVID. But they would take off like 4 months if they went to somewhere 5 hours away. I would tell my client to take it, because if they can get out in less than a year and the child is over 3, I often encourage them to take it if they are expressing to me that when the second they get out, they intend to hit the ground running. I'd also like to mention that social workers do have a responsibility, if we request it in court, to check in with that parent's facility where they're incarcerated and say, hey, here's a rudimentary investigation of if you offer anything. The answer is almost always going to be no, they don't offer anything. However, I've had a lot of clients, like more than 60% of my clients were incarcerated, where if they inquired of an individual in the facility, if there's a facility they can be transferred to that has anything, a parenting class, which is usually, run of the mill in our case plans. It's almost always slapped onto a case plan. If we can even get them into one thing, then you're inching towards substantial progress. I mean, then you're starting to, just like I said, go up that mountain to use that case plan to be on offense instead of defense. I mean, you're showing the client has dipped their toe in the pool and they're starting.
Again, this is one of those things where we can go in 5 different directions from this issue. There's so much to talk about, but I do want to spend some time here because it's important in the context of who we're presenting with, that parents in custody know what their rights are, and they actually do absolutely have a right to visit their child. Now, obviously, we're not asking that the court order the inmate to be released to visit. No, we're asking that the government, which had the incredible authority to remove a child from a parent, have also the obligation of facilitating or making sure that the visit takes place as long as the facility allows it. And by the way, most facilities, not all, but most facilities do allow visitation in some shape or form. And one thing we see in the courts, and if you guys are working on open cases, we'll see often courts will improperly not order visits for parents in custody due to inconvenience. But really, that's not a basis. The only basis, if you look at WIC section 362.1A1A, again, 362.A1A actually, sorry about that. If you look at that section, it says that visitation is the most important thing in reunification, that it must be done as frequent as possible, and that the only way that you not allow visits is if there's an actual finding that the visits would jeopardize the child's safety. Now, from what I can tell, a parent being in custody doesn't actually jeopardize the safety of the child, even if they're 1 or 2. And it is an aggressive ask in terms of perception to ask a 1-year-old to be brought to prison during COVID. But unless it's articulated that this child is medically fragile, for example, that it would jeopardize their safety, unless that detriment finding is made, visitation is absolute, even for parents in custody. That is their right. And I wanted to make sure everyone knew that. There is actually a case that's called In Re SD that's related to 50 other cases that say the same thing. Basically, the ruling from that case, In Re SD, is there is no go to jail, lose your child rule. And if you go to jail, like Ben was talking about, there's a number of options available for parents to take care of their child, such as making the appropriate plan, like Ben was talking about. But there's also some scenarios where it actually benefits the client if they're incarcerated for a long time, for example, where strategically it may actually benefit them to agree to removal of their child in exchange for placement with a relative, because remember, the one thing that a lot of parents will not know is if you're making an appropriate plan, if a child is with a relative under an appropriate plan, the government has no obligation to provide funding to take care of the child. But if the child is removed so that the relative essentially is the equivalent of a foster placement, then funding is required. So strategically, there is a move where like, all right, we consent or we submit to removal with that relative. And in some cases, even submit to not getting family reunification services in exchange for a child that's placed with a relative, and it just takes legal guardianship. That's called a 360A, WIC section 360A, where basically a parent gives up their right to reunify. You have an absolute right to have the opportunity to reunify absent certain circumstances, which come up every now and then. But just generally speaking, you have a right to have a chance to reunify. But sometimes parents can give up that right strategically because then the permanent plan is legal guardianship with a relative. And what's the benefit of guardianship? Can anybody share why we prefer guardianship over
Parental
adoption?
rights aren't terminated, and a lot
Exactly.
of parents may likely have another child. And if you have your parental rights terminated on one child, they have a hook in your neck and can get your other kids, even kids that aren't born yet.
And if your parental rights are never terminated, you can still reunify with that child actually. Adoption, the door is slammed shut, but the door remains a little open with legal guardianship through something called a vehicle called the 388 that I'm sure many of you have heard about.
And I also wanted to chime in for a minute and say that oftentimes when we work with clients that are in the process of being released or have been released, what's helpful when their children end up in legal guardianship in terms of their placement is that it allows the parent that time that they need to honestly reacclimate to coming out and figuring out what's going to happen and all of those many things that need to happen, but it gives them that extended window of time because they're no longer limited to that time that the court has determined for them to be able to reunify with their child. And as Frank was saying, there's that opportunity through a 388 further down the road to be able to get on point with everything that they need to do and establish themselves and get stable in every way so that they are actually in a better place to be ready to take back their role as a parent. And so oftentimes that's the next best thing that can happen, especially when we're talking about parents that are facing oftentimes long-term incarceration and are having to come out and trying to reacclimate. I'll speak about a case now that's precisely where we're at right now, and we're at a 388 because he served a long time. And one of the issues that we have before the court is the fact that this is a parent that repeatedly asked, and the attorney has it documented, where we repeatedly asked the court for the department to make every effort to facilitate visits so that the bonding between that parent and that child would continue. And our attorneys can speak about how important that is to sustain and maintain that when we talk about reunification, how it's an essential piece of that. But those are all the things that we can step in and do to be able to help hopefully end with a better outcome in cases like that when we're talking about incarcerated parents.
So I'm seeing some comments from Robert, and to extract a question from there is law, it's WIC section 361.3 that says that there is a preference for placement with a relative whenever a child is removed from a parent. And if you look at WIC section 361.3, there's a laundry list of factors to consider for why a child should be placed with a relative. But the law is pretty strong in that regard. There have been many judges who've been reversed on this issue when they kind of ignored, they basically ignored that the preference applies in all these cases. The most famous one I can think of is In Re Isabella G. That is an incredible case. So if you guys can just Google it sometime when you're free, it's a long one. It'll take a while to read, but it is an incredible case talking about grandparents who are trying to get custody or placement of their grandchild with them and going through extraordinarily frustrating measures before they were ultimately not allowed to have their grandchild placed with them. And then the Court of Appeal came back and slapped the juvenile court and said, I can't believe you, this is ridiculous. The law is clear. You did not apply the relative placement preference. So something to always consider when you're working with your clients and trying to find some place that that the child can be placed if you can't have the child placed with them in their custody. And also know this, at least in California, it's different in other states. There is something called a non-related extended family member, which is not a biological family member, but a family friend. And the bar is very low for what qualifies as a family friend. That person has the same status as an actual relative. So if you have a client or know someone who has a dependency case and they're from Virginia, they got no family in California, but they have a friend, they have a neighbor or something, or their child's school friend's parent. That person can qualify as what we call a NRFM, a non-related extended family member, and get that relative placement preference as well. So another thing to factor in when you're helping clients.
I have clients that ask me that question, and I am happy to tell them yes, the law has caught up with your understanding that that's completely fair to prefer to keep that child with people that child knows.
Yeah. I'm sorry.
There was a question about in re SD, and I was trying to find it to put it in the chat. Is it a non-reported case?
No, it's published. It's
Okay.
it's a citable case. And there's
Okay.
like, again, 50 other cases that say the same thing. I believe there's an in re JN out there as well that says the same thing.
Okay. All right. How much time do we have left? Not too much. Will you go on, Frank?
Well, I was just going to answer the question out loud. I don't know when we answer questions through the question Q&A section where if everybody could see the answer. Sorry, I answered a question about what if the judge gave sole custody to the mother, who then takes the children out of the country. I'll advance the scenario a little bit further. Let's say we have let's say it's the mother and the father is in custody. Sorry, do you want to handle this for everybody else to hear?
Well, honestly, I'm assuming the departure from the US would be akin to trying to get the children out of this case entirely. Am I understanding the question correctly? Or is
I mean, that's what I wasn't clear on either. Like, where are we in the case? If there is
a trip to Bermuda, or is this a parent that is using this as a way to get away from the person who's staying here?
Well, let's actually go over each scenario. If there is a parent in an open case, let's just follow the same fact pattern. Father's in custody, mother takes the kid out after that initial hearing / the detention hearing. She goes to Guatemala, let's say. That's a country that comes up in a lot of our cases. What happens next? Do you guys know?
Well, they can open a petition on her.
Warrant.
Yeah, well, yeah, a warrant, exactly.
The court's going to issue arrest warrants for the parents or whoever fled, and protective custody warrants for the children. Now, if they fled the country, the likelihood of success is slim, but we do see this when parents leave states, and they're often picked up, happen across the country. Yeah.
Now, let's say the scenario is that the case just JT, the jurisdiction was just terminated and the mother has sole custody. What happened and wants to leave to Japan? What avenues, if any, does the other parent have?
It definitely becomes a family court matter at that point, because when they do the exit orders from juvenile delinquency, from dependency, they send it to the family court.
Mm-hmm.
And then and there may be a pre-existing case or not, and then that's where I think that person might have to fight it.
Ben, what were you going to say?
Yeah, essentially there's nothing they can do to prevent it, especially for an incarcerated client. A parent with legal custody has the right to legally travel, get a passport and legally travel outside the country. Once they don't return, then yeah, I believe Ms. Sloan is correct. That would have to be taken up in family court, where the incarcerated parent would, I'm assuming it was, you still would have had a right to visit, essentially. When that custody order closed, even if the parent has sole legal and sole physical, there's still going to be a carve out for visitation. And so you'll only be able to enforce whatever rights you have. So if you have a right to visit 1 hour a week, if that's in person visit, which it almost always will be, you have that right and you can enforce that order in a family court. Now, I'm not sure what your local family court, what jurisdiction they would have or how they'd be able to enforce this if the parent is essentially fled the jurisdiction. But it's going to be a huge mess and a huge uphill battle. And even if you got a court in your local county to rule that mother violated the court order, there's not going to be a whole lot they can do to bring them back.
Let me also remind everybody how great it would be that these children are even with one of the parents. So this is like to me, this whole scenario is not even that bad.
Right. No, I agree with all three of you. We're not family law lawyers, or we go against the government, right? That's generally the position we have. But it's so when the operative term here is sole custody. If a parent has sole physical custody, what the other parent can do is pretty limited outside of family court. And the only scenario I could think of where you could do anything and it wouldn't be easy is that we change this fact pattern to not leaving the country, but leaving the state. If a parent leaves the state, like let's say the case closes, mom has sole physical custody, dad gets out of prison. He's like, all right, I have monitored visits and she has sole physical custody. I want to change that, but she lives in Alabama now. The law actually requires that the parent with sole physical custody, that it's her jurisdiction where you'd have to amend the custody order. So you wouldn't be able to go back to court in California and be like, hey, I want to change the terms of this custody order that this California court made. Unfortunately, the jurisdiction of the parent with sole physical custody is where you have to go. No, I made the same mistake. I'm looking at a question from Mignon. There is actually a rule of court that really threw me about 6 months ago. What happens, and again, we're talking about sole physical custody. And there's actually a box that's checked in our juvenile custody orders that says the jurisdiction of the parent with sole physical custody is the jurisdiction that applies. And there's a rule of court that lays out the procedure for how the case transfers to that other jurisdiction in another county. But I had this big fight over one of our judges that like, oh no, it's our court only that can amend these, and she was like, well, we went back and forth, but she had the authority correct, actually.
Frank, we have 1 minute left. It's a hard stop at 1:15 due to Zoom requirements. How would you like people to send you email with further questions, or would you like them to send it to me and I can forward, or what would you like to do?
If you don't mind doing the latter, if there's other questions that could be collected, we'd be happy to answer them. It may even lead to another presentation where we just roll over to another one. But this was fun. I appreciate you hosting and everyone allowing us to ramble about dependency.
It was fantastic. It was very interesting. I hope I didn't get involved too much. Mark, our technical person, thank you so much. And I'm putting my email again on the chat. It's Deborah, DEBRA @prisonerswithchildren.org. And I can be a liaison with LADL if you don't get all their information. And we have manuals that might be able to that we can send out to you. So any last thoughts before we get cut off?
I'm available to anyone all the time by email to answer these questions.
Okay.
Do you mind sharing your email in the chat? Maybe that would.
I popped it in
Or-
there.
I
Oh, you
think
put
you
it down?
just did.
Okay,
Yeah, and our website and your website, I think, are in there too. So I'm sorry we didn't get to hear much of what Cameron said, but this was great, and we're looking forward to having further webinars. We're going to see if we can come up with a regular presentations, and then and maybe we'll get MCLE for the next one. Okay, I guess
everyone.
we're done.
Thank you
Thank
for
you,
having us.
Go ahead.
Bye, everybody.
Bye, everyone.
It was great, and
I'm Sloan. You're wonderful.
yeah, and for somebody asking for attending, would we be credit for this meeting? I'm looking into it. If you email your bar number, I didn't get that done in time for this meeting, but I'm going to work on it, and so you never know. Okay. All right. Thank you so much. It
Thank
was
you.
great. It was
Be
great.
well, thank you.
Bye. Bye, everybody.